Hi, Anna. This is a slightly unconventional way of pitching you for the opportunity of having a meeting up at Gloucester, but I thought I'd give it a try. I've been doing these video bulletins on a website, redwoodlegal.co.uk, which is, my hobby really, and also a way of educating myself about the insolvency sector. I only have a couple of years' experience of insolvency. I'm primarily a financial mis-selling litigator. So anyway, hello, good morning, good afternoon, good evening, whatever it is. And I just wanted to use this short video as a way of attempting to persuade you and your fellow insolvency practitioners at Mazars to give us a meeting in order to convince you that it would be very worthwhile indeed for you to introduce to us around about 50 or 100 IVAs and bankruptcies for the purposes of running a trial operation alongside your existing in-house one. So that's what I'm going to talk to you about. The first thing I want to draw your attention to really is the ethos of our businesses. I'm a financial mis-selling litigator. I have a new law firm, Redwood Legal, that I'm just in the process of having authorised, and I'm working alongside a claims management company called Maple Leaf Financial, who have a office in Oakham, Rutland Water. And I'm here based in central London. This is my office here in the Nerve Centre in central London. And I have this relationship with the claims management company, Maple Leaf, in Oakham, Rutland Water. Now, our ethos, really, from day one, has been to create quite a close relationship and to go after just one or two large insolvency practitioners. We are currently also meeting with RSM Tenon at the end of the month, and we don't want to be greedy. We are not looking to make huge amounts, shed loads of money on the basis of a volume operation. We just want to focus and to distinguish ourselves from the competition by processing a reasonable quantity of payment protection insurance in bankruptcy and insolvency and IVAs to its maximum potential. And that's something that we want to do for the long term. Now, by way of our credentials on that basis, I am a financial mis-selling litigator, and I have been bringing payment protection insurance claims for the past 3, probably more like 4 years, with a great deal of success. And I'm unashamedly, I'm unashamed about that success. And I have basically fought tooth and nail on behalf of consumers all the way to the courtroom doors. Very rarely is a trial necessary. Usually we spend a whole day in court arguing in order to get not just some compensation, but full compensation. And I really do think that a lot of other service companies are more focused on turnover and are not so focused on maximising the realisations themselves. And I think that's absolutely key, both because in terms of having a properly compliant operation, but and also simply in generating the maximum returns and making sure that there aren't any problems or bugbears down the line. I just, by way of example, this is I am working retained by Maple Leaf Financial as their in-house lawyer. This is an example of a client that we've had very recently, and the banks have made an offer. Their offer of refund was £6,500, and we have written back to them and basically said you've incorrectly calculated the refund. I don't know if you can see that, and that we believe that the refund that the client is in fact entitled to is double that. We've asked for an additional £6,900. This is on the back of, and here is the estimate we've produced, which calculates, this is a credit card case. Actually, it's a fixed term loan where the client also had a credit card, and we think that they've basically applied the wrong interest calculator on the premiums in this case, and as I say, they're entitled to double the amount of money. So that just, quiz us by all means on this if you do decide to invite us in for a meeting. because I don't think that everybody out there, whether they're lawyers or claims management companies, are maximising their returns. And I was in court with MBNA in June 2011, having taken a claim, an offer from them initially of £3,500. We settled on £6,750 at court. And although they've thrown in the towel on the PPI mis-selling scandal, they aren't always, and I dare say, not just a minority, but a substantial minority of cases, they aren't paying full compensation where PPI has been demonstrated to be missold. So we are interested, as I say, in maximising our returns. Now, in terms of, I think one of the problems that insolvency practitioners are going to have with existing CMCs, and I talk anecdotally about insolvency practitioners that I've spoken with, they're going to have problems with claims management companies or law firms that have not maximised their returns and also have not fully understood the law insofar as PPI in insolvency is concerned. And I'm specifically talking about, for example, where a bank, where a firm, a lender, has chosen to set off the payment protection insurance. In what circumstances are lenders entitled to, creditors entitled to set off, and in what circumstances they're not entitled to set off? Now, you can have a look at my website, as that's an area of particular interest of mine. I have experience with 2 law firms, having set up a unit at one law firm and having consulted in the setup of a law firm at of a unit at a second law firm. You can have a look at those. Talk to me about those operations, and basically, you have got a situation where unless you fight your corner hard and aggressively, the banks there's a danger that the banks will set off PPI claims, and it could amount for as much. I would say 25-30% of claims are in danger or susceptible, if you like, to set off. And I am party to the stats that are being produced by the second law firm, and I can tell you that we have been surprised by how often a creditor, if you approach the matter aggressively and firmly, how often they will capitulate on set-off. And I hear generally that is something of an issue for the insolvency practitioner. Generally, you may be experiencing set-off problems yourself currently with your in-house work. So I think what I'm saying is that in order to satisfy the ethics code and to make sure that you've done a good job, you need to make sure that you're fighting these particular battles, set-off being one example. And an operation such as ours combines a law firm here based in London with a claims management company based in Oakham, Broughton and Water, and we will take the problem of set-off as well as any other issues that may arise off of your plate, and we won't be pestering you day in, day out about what to do with a particular creditor's position on the issue. We'll be able to act fully as your agents and take responsibility for being your agents in terms of dealing with these sorts of issues and properly understanding the law in this area. So that is really the end of the video. Just to sum up, we want to impress upon you that we're looking to take on only 1 or 2 large insolvency petitions, probably 1 ultimately. Then we've got 1 large insolvency petition, a number of medium or smaller insolvency practitioners, is to spread the risk for our business. And we then are going to run an operation where we really are going to gun it and make sure that whether litigation is required or not required, or whether it's just a case of properly processing the claims through the Banks Now complaints process and through the Financial Ombudsman Service, we're going to make sure that we maximise returns. So if you would like to meet up with us and talk more through these issues, I do urge, and perhaps if only for the sake of the regulations and to make sure that you're compliant, that you get a second service company, whether it's us or somebody else, alongside your existing in-house operation. And that's got a good precedent with another large insolvency practitioner I know. And then you can monitor the performance of yourselves and the costs of processing PPI in-house as opposed to using a service company. Then it will help build up a relationship so that if you do feel that you need to farm out your entire workload of PPI insolvency to a service company, then you can. Finally, one has to look to the long-term future in terms of other potential financial mis-selling claims such as interest rate swaps, mortgage mis-selling, and as I say, unlike we are specialists in the financial selling field, whether it's law, advice and assistance here, litigation here, or whether it's processing in greater volumes from the operation in Oakham, Brupton Water. So many thanks. Do get in touch if you would like to meet us. I'm very happy to come up with the team at Maple Leaf Financial and visit you in Gloucester and give you some free consultancy, some background knowledge. I've been working in the sector now for a couple of years and I have a wider experience of what everyone else is doing. So you can get some free consultancy, introduction to the area, and we can put a pitch to you, tailor-made pitch to you as to how we might go about building putting down a small building, small cornerstone or building block in terms of taking on a trial batch of cases from Mazars. So thank you for listening, and don't hesitate to get in touch.